The past few weeks have been a particularly busy time in South Africa for anyone dealing with data protection laws, with the grace period under POPI fast approaching its end. During this time, I have seen clients both in the public and private sector who are fairly relaxed that they are on top of their POPI readiness and compliance programs, and in fact are in their final stages of implementation and rollout across their business. On the other hand, many clients who engage in complex data processing activities are overwhelmed by the real challenges they face with the practical application of this new law. So it's leaving many with sleepless nights on whether they're interpreting the language of POPI correctly or not. This is also as POPI is a principle-based law. So it tells you the standards or principles that you are required to comply with, but not necessarily the how-to. So today's discussion with the South African Information Regulator is timely, as you will receive answers straight from the authority. So the aim of today is for you to walk away with practical information from the regulator to help you navigate some of the key compliance requirements of the Act. At last count, you are one of just over 960 participants today, so welcome. My name is Preeta Bagaji, and I'm a director in Cliff Decker Hoffmeyer's Technology, Media and Telecommunications practice, and I'm also the TMT sector head. And these days, like many of you, I eat, sleep and breathe POPI. So hearing the views of the regulator today will be very helpful indeed. We are joined from the Information Regulator by part-time member, Professor Sizwe Snail Ka-Mtuzi. Professor Snail is an accomplished ICT lawyer with many years of experience, and he holds various degrees and amongst other things is adjunct professor at the Law Society at the NMU. With him, we are joined by Ms. Varsha Sular, who also has a string of impressive accolades. She is the Executive Director for Legal Policy Research and IT Analysis at the Information Regulator, and is currently studying towards a doctorate in ICT law. I will be moderating today's discussion, which will include fellow Cliff Decker Hoffmeyer directors, Adil Patel and Lucinda Rudy. Adil heads up the firm's employment law practice, and Lucinda sits in our dispute resolution practice. They each bring to the table the lens of their respective areas of specialization in unpacking the application of POPI. The CDH multidisciplinary approach to advising on data protection matters allows us to provide holistic advice on what can sometimes be complex legal considerations affecting our clients' businesses. We have allocated some time for Q&A where you will be given the opportunity to pose questions to the panel. You can submit your questions by clicking on the Q&A icon on your screen. So the Information Regulator has certainly been busy in the last few weeks. We have seen the much anticipated guidance note on information officers published a short while ago. And then not long before that, the guidance note on prior authorization, as well as the codes of conduct were issued. We will be discussing these guidance notes with the regulator today. In addition, we can also expect more from the regulator. They have indicated that there are more guidance notes in the pipeline and likely to be published in the coming weeks leading up to the 1st of July deadline. There are guidance notes expected on exclusions and exemptions to POPI. There is a cross-border personal information transfer guidance note expected, also in respect of direct marketing and on the processing of special personal information. Indications are that there are also some regulations that are likely to be in the pipeline. So before we get into a discussion on the recent guidance notes, I thought that we should start by talking to the regulator about their role, the role of the regulator itself. And the regulator, as you know, has been established in terms of POPI, and it's required to be independent and impartial in performing its duties. And of course, it's empowered to monitor and enforce compliance not only with POPI, but also with POPIA. And quite importantly is that it is tasked with consultation and engagement with interested parties and the public. And in this vein, it issues codes of conduct and makes guidelines. So this appears to be akin to the EDPB, who does a similar function in issuing guidelines, statements, and best practices in respect of the interpretation and application of the GDPR. So we'd be very interested to hear from the regulator today about the legal status of the various guidance notes that have been issued by the regulator. So I'll ask Varsha to address you on that issue.
Good morning. Thank you for the opportunity of being part of this, and I look forward to the engagement today. In answering your question, Preeta, the guidance notes are not statutory codes. They serve as an interpretive aid, and if we look at the powers, duties, and functions of the regulator in terms of Section 40 of POPIA, some of those powers, duties, and functions, refer to providing education by promoting an understanding and acceptance of the conditions of lawful processing of personal information, together with undertaking educational programs. And all of this is to ensure that there could be greater understanding on the legislation. So the guidance notes in terms of, they're not statutory codes, but merely serve as an interpretive aid to the Act. Thanks.
Thank you, Varsha. And I suppose leading on from that, it would be useful to understand, as we have many clients that have recently asked us, how they go about engaging with the regulator, and more importantly, what your role would be and how you may be able to assist if, for example, a client is struggling with working out whether they are in fact compliant or whether in respect of new data processing activities, it would fall within the requirements of the legislation, and the question is often whether the regulator could be called upon to give some kind of either guidance or a ruling or an opinion in respect of this. Varsha?
Thank you for that, Preeta. Yes, the regulator can most certainly be approached for guidance and to assist with interpretation. I think the one thing that we might just be hesitant about is, and that we don't do, is we don't render legal advice. Because I think the whole issue of whether there could be a conflict of interest somewhere along the line does arise. So I think the regulator will be careful about that, but will definitely be trying to serve as much assistance in interpretation as possible. Thank you.
Thank you, Varsha. So can we confirm then that if clients are keen to get your view or to meet with you to discuss their requirements, that that could be easily done via your office?
Yes, it can. I think we've got a general email address, and requests can be submitted in writing, and those will be considered, and we will most certainly revert to requests that have been made. Thanks.
Thank you, Varsha. I think we will share with the audience the relevant email address after the session. Thank you for that. Okay, so if we move on to the burning topic of information officers and deputy information officers, of course, many businesses preparing for compliance have been planning in order to make sure that they meet the deadline. Initially, the deadline was set at the end of March based on the draft guidance notes. of course, we now know that that deadline is 1 May. And given that it's only a few weeks away, I think that many in the audience would like to understand from the regulator the process to register, and much of it is contained in the guidance note, but it would be useful to hear from the regulator what the likely next steps are, and what companies should be doing to make sure that they meet
well, let me just try to
respond. Is that lost connection? Hopefully I'm back now. So I'm not sure where I dropped off. So I'll just repeat. So Varsha, we were hoping to hear from you in terms of the process to register information officers and deputy information officers, and on a practical note, given that there's been indication that you would open the online registration around the 1st of May, with Regulation 4 coming to effect on the 1st of May, are we to understand that that would mean that, notwithstanding the provisions of Section 55, information officers who aren't technically registered as yet, it may, for example, take them a few days to register, that they would in any event have to implement Regulation 4?
Thank you for that question, Preetha. Yes, the 1st of May would be the deadline for registrations, and I know there might be a lot of concern around how many applications the Information Regulator is going to receive and whether or not our systems are going to be able to hold that capacity. Presumably at this stage, we are saying that you have to register online, and I don't anticipate that there's going to be any other concern that may arise. We're hoping that our technical team will also be, able to assist us should there be any problem. But I think what we will, if there is an issue, which I doubt there will be, and I'm hoping that there won't be an issue, our communications team will certainly communicate any alternate arrangements that might need to be made. But for now, we're hoping that the system can accommodate all registrations. Thanks.
Thank you, Varsha. So that's useful input. So to the audience, it's best that you get your paperwork ready sooner rather than later. Then we would like to look at the question of who are the information officers, and again, we've had a lot of questions around this, and possibly some of the interpretation has resulted in much debate in data protection circles as to the interpretation of higher read with POPI in respect of, particularly for private bodies, the ability to delegate the role of the information officer, and in particular to someone outside of the information of the responsible party. So in other words, an often cited example is that you have a group of companies and they would ideally like to appoint a central information officer. The guidance note seems to clarify certainly the regulator's position by saying two things. One is that for private bodies, each responsible party has to appoint an information officer within that body, and not an external person. And secondly, that each responsible party has to have its own information officer. So I'll ask Varsha to come in on that question. Thanks.
Yes, Preetha, thank you for that. I think the guideline does stipulate who and who can serve as an information officer. So I'm not going to really go into that, But I think the issue on delegation, because there was something that you said about how would you delegate a deputy information officer, and how would that actually unfold? So the information officer, in terms of section 56B of POPIA, has a discretion to delegate that power to a DIO of a public or private body. So an employee of that body would be able to serve in that role. And in I know there is also the question of what is the difference between designation and delegation. In terms of POPIA, POPIA automatically designates a person in each organization as an information officer by virtue of the position that they occupy. So Section 17 of POPIA basically provides that the designation of a DIO of a public body, and Section 56 of POPIA extends that designation of a deputy information officer to that of a private body. So only employees of a body can be designated as a DIO in terms of the interpretation that the regulator has. And in order to render a body accessible as reasonably possible, then information officers of public and private bodies must designate one. They can designate one or more information officers, and that would be contingent on the structure and the size of the body and the nature of the activities that they occupy. And I think the other question that you asked, if I'm right, is that you know, how do you decide what are the obligations? So I think from that point, the default position in a private body is that the CEO would be or an equivalent officer would serve as an information officer. And I think in terms of also the guidance note, any person authorized as an information officer should be at an executive level or equivalent position. I don't know if I've answered everything that you've put forward.
Thank you. That was very useful and a lot of information. And maybe if I can touch on that last comment that you've made about the facultative level or equivalent. Could you unpack that for us, please, in the context of where you have smaller companies, for example, that may have flatter structures, and you know, how rigid in the regulator's view is this requirement? Is this merely a guidance, and or do you have strong views that this should be very rigidly implemented?
Preetha, I think that, you know, when you look at POPIA, and if you see the word person in the definition of POPIA, you know, used in paragraph C of the definition of the word head in section 1 of POPIA, it makes reference to a natural person and not a juristic person. And so when you read this definition together with section 17 of POPIA and sections 55 and 56 of POPIA, it follows in our view that the information officer of a private body does not have the authority to delegate his or her functions to a juristic person or third-party juristic person. So I think when you talk about smaller entities, it would still be, and the rationale behind that would be that it has to be someone at executive level who would be accountable and be in the best position possible to serve as an information officer. And I'm not certain as to how rigid it's going to really be, but if that person is at an executive level, then that should suffice, because section 55 of POPIA also deals with the duties and responsibilities of information officers, and that does not make provision for the delegation of functions to a juristic person or third-party juristic persons. So I think when you look also at section 17.3 of POPIA, it does not make provision for the delegation of functions of the information officer to a juristic person or third-party juristic person. Thanks, Preetha.
Thank you, Varsha. Another question under the information officers related to the clarification in the guidance note that the information officer for a company has to be the supplier and POPI. Could you comment on that, please?
Sorry, Preeta, can you please repeat that? You kind of tapered off.
So my question, Varsha, if you can hear me now, is that the guidance notes clarify that the information officer appointed under PIA is the same information officer for purposes of POPI.
Oh, yeah, yes, it is. We don't, in our interpretation, there's one information officer. And I know this question has come up quite often as to whether you can have an information officer for PIA and one for POPIA. And it's our view that in terms of the Act, there's provision for an information officer. And it doesn't prevent an information officer from delegating a DIO to deal with POPI matters and to deal with PIA matters. Thanks, Preeta.
Thank you, Varsha. So the last question for you in relation to the information officers and then in particular the deputy information officers. Could you tell us a little bit more about the difference between designation and delegation of deputy information officers and how this would work in practice? By way of an example, if, for example, a bigger company appointed or sought to appoint multiple deputy information officers.
Thanks, Preeta. Yeah, I think I did touch on this earlier, because when you look at PIA, it automatically designates a person in an organization as an information officer just by virtue of the position that they occupy. So if you look at the provisions of Section 17, it provides for the designation of a DIO, and then when you look at and thereafter, information officers of both the public and private body may delegate any power or duty conferred on them. So that is our understanding of the distinction.
Okay, thank you very much, Varsha. I'm going to hand over to my colleague Lucinda Rudy, who's going to discuss codes of conduct.
Preeta, we seem to have lost Lucinda.
Adil, if you're on the line, would you like to come in?
Yes, thank you for that, Preeta. The question from POPIA and its interplay with employment law is going to be a bane of contention for many employers. And one of the primary issues is that employers usually undertake employment law checks prior to employment or during employment. Consequently, the issue that needs to be unpacked is what is the difference between criminal history as set out in the definition of personal information and a criminal behavior as dealt with under specific or special personal information. Professor?
Hi there. Yes, I missed the first part of your question. If you can just repeat that, we had a bit of a connection.
The definition of personal information talks about criminal history. Right. And we then have what is the difference between criminal history and criminal behavior for the purposes of conducting employment checks and the necessary authorizations, Professor. Thank you.
Thank you for that. I think criminal history relates more to actual convictions that are listed in your criminal profile should one make an inquiry about yourself. I think the word criminal behavior in itself relates more to, behavioral characteristics and not so much the personal information aspect, which would be the criminal record itself. That's my view on that.
Thank you, Professor. That's interesting, and it's certainly going to guide our colleagues when they do pre-employment check histories, when they need to undertake criminal checks during employment. The distinction is of fundamental importance. Thank you. With that, I'm now going to.
Maybe I can also just come in a little bit, if it's okay. I think also, even when employers are performing these reference checks, the important thing is that when they include criminal and background checks, there has to be compliance with POPIA. And how do they acquire that information? How is that information stored? And how will they process that information thereafter? That's, I think, for me, those are the things that should be foremost in somebody's mind. But I mean, I think we need to make reference to Section 36 relating to the exceptions that may be applicable before that information may be secured. So I don't know if that adds anything further. Thanks.
No, it does. It adds some fascinating input.
But yeah, I think also that Section 33 of POPIA, also stipulates that an employer has to act, in accordance with all prescripts and labor laws. Even though I don't think the labor laws really go to the extent of protecting personal information to that extent. So thanks.
Yeah, I think in addition to that, one should also mention the fact that, criminal information would form, special personal information, and that the regulator is currently considering a guidance note on special personal information, which will most probably also be dealing with this particular aspect as well.
Thanks, Professor, because what we're going to need to do, at least as employment lawyers, is once the guidance note comes in, is to re-look at our recruitment policies and procedures as to how we marry the two, so that we ensure that the people we employ have the right credentials for the post that they're going to occupy, and that there's full disclosure in their CVs about any of these sort of information, as well as whether they have a criminal history and how we obtain that information. Thank you, Professor Anvarsha. I'll now hand over to Lucinda. Thank you.
Thanks, Audio. Good morning, everybody. Professor Snell, I would like to discuss a few issues with you in regards to codes of conduct. We saw that the regulator yesterday gave notice in terms of Section 61.2 of POPI that it is in receipt of a code of conduct from the Credit Bureau Association, inviting all affected persons to submit written comments to the regulator by the end of this month. Now, we know that Section 60 and 61 of POPI empower the regulator to issue codes of conduct either on the regulator's own initiative or on the application of any class of body, industry, profession, or vacation that, in the opinion of the regulator, has sufficient representation. Now, can you possibly just give us an indication and maybe elaborate on the factors that the regulator would take into account in order to determine whether a body making application for the issuing of a code of conduct in fact has sufficient representation as is required in terms of POPI?
Yeah, that's a very interesting question, because when we drafted the regulation right at the beginning, we had said, anyone who brings an application would have to obviously prove that they are sufficiently representative of that particular industry or that class of persons. So I think it's a case-by-case analysis. What I can, however, say is, the codes of conduct are not just for the taking. So, you would really have to show to the regulator, if you say, let me say for purposes of this question, let's say there would be a telecoms group coming saying that, they want a telecoms code of conduct. That group would have to show us, that indeed in the telecoms industry, they are, having stakeholders, they're having members, they are having the clout which they claim to have, which would, give a reason for the regulator to even want to consider the possibility of having a particular code for that telecoms industry. So I know it doesn't answer the question directly, but like I said, it's from case-to-case basis. But the warning word which I can give is that, once again, they're not just for the taking. If one looks at various jurisdictions, you have some jurisdictions that have 4 or 5 codes. You even have 2 or 3 of the comparative jurisdictions that we use, where there's only 1 or 2. So it's really something that you and your client, and I'm speaking as a lawyer now, it's something that you and your client would have to evaluate and to see whether indeed you are sufficiently representing that particular group or that sector. And then once you are satisfied with that, you would then obviously have to give us documentation to that effect to say, we are so and so, this is our members, this is our constituency. We, according to us, we are 70% representative of the entire industry, something like that. And then based on that, we will then take it further.
And I think if I can add, Prof. Snell, if you look, I think Form 3 is a bit instructive in that regard, because Form 3 will require you to list the class or body or any and the industry size, the profession or vocation that you represent, and then you need to obviously attach the proof of representation. So then the total number of members of that industry or class of bodies, profession or vocation, would be instructive in determining sufficient representation. So, and I think even when you look at Form 3, it basically says, so to whatever you submit to the regulator, you must be able to reflect the proportion of your representation, and as a percentage. So the proportion of representation in that industry, class of bodies, profession or vocation, and that would be instructive for the regulator in determining sufficient representation. I hope that also adds to it. Thanks.
Yes, it certainly does. Thank you very much. And I think if one also links that up with guidance, paragraph 10 of the guidance note that was published in February, where it also says that, the relevant body must ensure that it has sufficient resources for the development and implementation of the code. And then it lists 10 factors or requirements that the relevant body needs to comply with. So that leads me to my final question for Professor. Now, we know that the regulator, in terms of POPIA and also the guidance note and the regulations, may issue these codes of conduct only after consultation with relevant stakeholders. So the guidance note sets out the form of the consultation that may take place, and provision is of course made for written submissions to be made by the public, and the regulator is then directed to consider any such submissions made within a specified period. It doesn't seem to make provision for any direct oral engagement with affected persons. So does the regulator envisage maybe developing the guidance notes further, or a process almost akin to a public hearing that would allow affected persons who wish to engage with the regulator by way of oral submission, or would the consultation process only ever be limited to written submissions?
Yeah, you know, on that, there is a guideline that we have published as a regulator pertaining to the application of codes of conduct. And I think the guideline also sets out, you know, how these forms of consultation should be. As you've correctly said, you know, nowhere does it say that there must be oral submissions or public hearings and so forth. Therefore, I think, and I'm really carefully using the word I think, it would be limited to written submissions, but I think as well, if it were something that really affects the general public, the regulator does have the power to you know, solicit other forms of consultation, if it really has to be. So, I mean, there is the whole thing of, like you saw, a notice on the website. There is a publicity principle there to try and ensure that everyone who's affected should know about this. So, and if you look at the process, it really insists on consultation, not just only on the level of the regulator, but before you even bring your code, you must have thoroughly consulted with your own constituency, your own people on these matters. And part and parcel of your application to the regulator, and you'll see this in the guidelines, you would have to give proof that indeed you have sufficiently consulted on that level as well prior to bringing the application. But like I said, you know, that is something that one can consider. And I think in the future, the regulator may give further guidance on that. I unfortunately can't take the matter further.
Prasnil, maybe I can add to what you said. I think what the guideline says is that the consultations with the relevant stakeholders may take. So it doesn't preclude public consultations. It says may. So for me, I think that the regulator hasn't omitted the possibility of physical consultations with affected stakeholders, but it just says that it may. So it doesn't exclude public hearings. You know, it just says may. Thank you.
Thank you, Professor Snyder, and thank you, Versha. That was indeed very enlightening and helpful. Prita, back to you. Thanks.
Thank you, Lucinda. So I think, Versha, you're up again. We're going to dialogue about prior authorization. And again, in light of the guidance note recently issued by the regulator, I wanted to unpack the components of Section 57 and perhaps get your views on how this would work in practice. Many of the attendees have been scratching their heads in some respect in terms of, in this case, interpreting the words in the section. So if I split it out into each of the separate types of processing activities for which Section 57 requires that prior authorization is obtained from the regulator. The first one being that if a responsible party processes unique identifiers, collects it for one purpose, but then links that information with information processed by a second responsible party, then in that case, prior authorization is required. So on the first score, there's been some guidance given in terms by way of a list of unique identifier would be. Could you elaborate on the context? And you know, many would argue that some of these unique identifiers may not necessarily in this context and the context of requiring prior authorization. So if you're able to share your views on the rationale for the set of examples.
Thank you for that, Prita. I think that the guidance note, well, you know, it looks at and furnishes examples of unique identifiers such as bank account numbers and policy numbers, identity numbers. And I think the whole norm is that if you can, it's not, if you are able to link that information to a specific party, and then the whole process for prior authorization would have to unfold. You did say something about if information was being linked and utilized by an associated or somebody linked to a responsible party. I think for me, in that respect, consent will be quite critical as to how how would you deal with an application for prior authorization if the responsible party had secured consent and that consent completely deals with the very purpose for the information being utilized, then there wouldn't be an issue with that. When it comes to dealing with how unpacking how an application for prior authorization is going to be dealt with, I think the guidance note gives some details on how do you complete this application form, and once that information has been completed, then the regulator, that would be the basis for you to submit your application for prior authorization. If you're going to be complete the look at the guidance note and complete the application form duly, because you're going to be looking at instances of criminal behavior, looking at unlawful objectionable conduct of a data subject on behalf of third parties. The issue of credit reporting, we are going to be dealing with a code of conduct from the CBA, and I think that we'd be able to unpack much of that from there. When you're looking at the transfer of special personal information or personal information of children to a third party, then the responsible party that intends to transfer that information to a third party, a party outside the border of the country, must assess if the third party of that foreign country, whether they're subject to a similar law, binding corporate rules, or a binding agreement. And I think that the essential factor there would be, does this country provide an adequate level of protection that would uphold the principles of reasonable processing of personal information? And is it substantially similar to the 8 conditions for the lawful processing of personal information in relation to data subject? So for me, that would be a good benchmark as to how these applications are going to be considered, because the regulator is going to have to assess on that basis. Thanks, Peter.
Thank you, Varsha. So maybe if I could play back the information that you've shared with us, and if I look at 57.1 actually, which is the unique identifier processing in the context of 2 responsible parties. So if I understand you correctly, what would not be requiring a prior authorization is a situation where, in fact, there may be linking of information between 2 responsible parties. However, the information, each stream of information has complied with the principles of POPIA. So in other words, there is clear consent and transparency with the data subject in respect of obtaining specific consent for the linking of information and potentially sharing it to the other responsible party and disclosing the purpose of that. Would it be correct to say to confirm that is not prior authorization? Of course, there may be a code of conduct that deals with this, in which case prior authorization may not be required as well.
Yeah, Preeta, I think that if that's the case, I mean, the issue of consent has to be full disclosure as to how that information is going to be utilized. And in that instance, I can't see why you would have to, another application would have to be made. It should be adequate. I mean, it's also difficult to give you a general overview because it's going to be contingent on the particular processing activity, and whether, but if consent has been adequately secured and the data subject is fully apprised of the use of that information, I don't see a problem with it at all. Thanks.
Thank you, Varsha. All right,
so
and then
the thing is, if there's a code of conduct that has been issued, then I mean that would also address some of the issues that that has been raised. So it might be covered by a code of conduct. Thanks.
Thank you. All right, so if we go down very quickly through the rest of the provisions of or sub-clauses of Section 57, I think we've covered criminal behavior. I wanted to touch on credit reporting, and there has been some discussion already on the credit bureau position. The guidance note specifically, in fact, the Act doesn't define the term credit reporting, but the guidance note does. And your comment in the guidance note in respect of credit reporting relates to any credit bureau, any person processing personal information for credit reporting purposes. Would you be able to give us an indication or examples of what you were intending to cover in that context? So, for example, I'll just read out for the benefit of the attendees the definition of credit reporting under the guidance note. It says that it refers to the processing of personal payment history, lending, and creditworthiness of a data subject by creating a credit report based on that information, and lenders or credit providers use credit reports along with other personal information to determine a data subject's creditworthiness. So, you know, one of the questions would be that would credit providers in assessing and in terms of the relevant legislation that applies to them, make an assessment on creditworthiness, would that be considered credit reporting for purposes of Section 57?
Varsha, you're on mute.
Oh gosh, I'm so sorry. Subject to Section 57, I think it's Section 57(3) of POPIA, where credit bureaus are registered with the National Credit Regulator or any person processing personal information for credit reporting purposes. So they may apply for prior authorization from the regulator. That is my understanding. Thanks.
Thank you, Varsha. All right, so we are going to take some questions from the audience, and hopefully Prof. Snail, there you are. All right, so one of the questions relates to cross-border data transfers, and this is the question of adequacy, and in terms of Section 72, what would be considered, or which countries would be considered meeting the adequacy requirements in terms of Section 72, and in particular, how would the issue of juristic persons being included in the definition of data subject factor into that?
Maybe I can try to respond to that. I think in this regard, the regulator hasn't made a determination as yet on adequacy and which countries are deemed to be adequate at this stage. We are going to be issuing a guidance note on cross-border data transfers. Though for now, there hasn't been any country that has been determined to be adequate. And I mean, I don't think that the regulator has precluded engaging with other regulators in this regard, you know, to try to ensure that that, you know, there is an adequate level of protection, and residual regulators you can confer and prepare a list on adequacy. I think that would be of great benefit to responsible parties, but it's still work to be undertaken by the regulator. And even if you look at other regulators internationally, many of them are still, this is work in progress. Thanks.
Thank you. So would the following be something that you believe would be workable until that clarity is received, that responsible parties conclude the agreement in which they enshrine and contract for the principles of POPIA? Would that be sufficient in your view?
Yes, for now it would, barring any adequacy decision that has been made by the regulator.
Thank you. Great. Another question for the panel is that this attendee would like to know about data breach notification and whether that is a requirement before the grace period expires. Varsha, I'm not sure if you want to take it. Is Professor Snail still there? We might have.
Yeah, it still is a requirement. I mean, you'll see that even in we've had previous breaches, and I'm not going to mention any names, but I mean it's imperative that should there be a data breach, that the information regulator is informed. Thanks.
Thank you, Varsha. All right, then there's another question about legitimate interests and whether responsible parties in South Africa can look to guidance from the GDPR and the UK for interpreting or working out a test for what legitimate interest may be under POPI. Is that something that the regulator has given some consideration to?
Maybe I can take that. I think if we look at, we are going to be issuing a guidance note on legitimate interest. And if I take you back to, I think it's section 2B of POPIA, where POPIA will regulate the processing of personal information by establishing conditions that are in harmony with international standards that prescribe minimum thresholds for the lawful processing of personal information. And if you look, if you consider section 2B of POPIA, I think that it's safe to assume that the regulator will be benchmarking with other regulations. And I mean, I think that in terms of the GDPR, they have a three-pronged test where they look at purpose, necessity, and balancing. And I don't believe, even though this might not be exhaustive, I don't believe that that the regulator will not be considering something in a similar vein. For us, it's even though those are not the only factors that you can consider, but I think it's a solid benchmark in any event. Thanks.
Thank you, Varsha. All right. Then there was a question in respect of data retention. So with compliance in respect of section 14, where there is an example of a potential litigation of a class of information. So in other words, not a specific litigation at present, but a propensity for litigation to ensue. Would that be sufficient to meet the requirements of section 14 to continue to retain that information in the context of a propensity for litigation to ensue? So in other words, it would be required by that responsible party to continue to keep it. And I suppose the question would be whether one could place a legal hold and use that mechanism for a class of information.
You know, Preetha, I think that this is also one of the matters that the regulator is going to undertake a guidance note on. But Section 14 deals with the retention and restriction of records of personal information, and it does prescribe that records of personal information should not be retained any longer than is necessary for achieving the purpose for which that information was collected or processed. But I mean, if you look at the exceptions, you know, for example, where retention of the record is required or authorized by law, and also, you know, if you're looking at retention for historical, statistical, or research purposes, but your example relating to litigation, I think that would fall within the ambit of those exceptions, in my view. Thank you.
Thank you. So there are a few questions in respect to the process for registering information officers and deputy information officers. So there's a question around when the online portal will be opened.
We anticipating, I mean, as published, that the online portal will be open from the 1st of May. We're busy with the testing phase at the moment, and we're hoping that it's going to be all systems go from the 1st of May. Thanks.
Great. So tying into that, if someone is asking whether they can in fact use the forms that are currently available and submit via email in order to meet the deadline. A related question is there any penalty if they do not register on the 1st of May?
I don't think I'm going to say anything about penalties as yet. I mean, the Act is pretty specific about penalties, but I think that we are trying to make sure that it's not a manual process. I mean, we can't bar a manual registration, but the regulator is trying to make sure that it's not manual. So as far as possible, we would suggest that you try to make sure that you register online. If there is a problem, then only, you know, a manual registration process would be acceptable. And yes, you can utilize those forms. I mean, that's the reason that those forms were prepared. They might seem basic, but I think when you're looking at your delegation internally, then you can include more information as to the powers of delegation, and so I think your internal documents can be a little more substantial, but the forms that have been provided must be completed, and they would suffice. Thanks.
Thank you. Another question is, if the CEO is the information officer by virtue of their position, so in effect the head under POPIA, and they wish to authorize somebody else, and in terms of the guidance note, that would be an employee in that organization. The question is, do they need to disclose both the information of the CIO and the information officer who's been delegated by them, and do you need to provide the actual delegation documentation to the regulator?
Did you say CIO? Because that would be different.
Sorry, CEO. Apologies.
Okay, no, sorry. Okay, no, we don't require those documents, but the norm is that you would register the information officer and whichever deputy information officer that have been delegated. So you would register them both.
Okay, thank you. We're almost out of time, so I think we're going to wrap up with the last question, still staying on the information officer topic. So the question is that if the requirement for companies within a group of companies have to each appoint a separate information officer, is it acceptable to have one POPIA manual and privacy policy that encompasses all of the processing across the different responsible parties.
You know what, as far as I can tell, that every responsible party must have a POPIA manual. And the reason for this is because in a group of companies, each group is going to be processing personal information in a different way. And in that regard, each responsible party would have to have a POPIA manual so that they could address the processing activities that particular entity undertakes. Thanks.
Thanks, Varsha. So on that, would it be possible in one POPIA manual to stipulate each responsible party's details and then stipulate the processing activities separately, but in one POPIA manual? Is that are you saying that's not likely to be acceptable?
You know what, I'm not 100% certain, but I think that it would be preferable if there are separate POPIA manuals. It would make it I think it would also be more user-friendly for data subjects. And when developing a POPIA manual, I think you need to be mindful of, is it going to confuse the data subject? Is it going to be clear as to how how they would be able to access information if required? So for me, in my view, I think a separate manual would be beneficial because it would assist a data subject, and that should be the determining factor. Thanks.
Thank you. Thank you, Varsha. So to the audience, there are a number of questions that we've unfortunately run out of time to get to. The Information Regulator has very generously agreed to assist with collating responses to some of those questions. So we will share them with the regulator and be in touch with you in terms of providing you with response. So I'd like to thank both the Information Regulator as well as you, the audience, for attending and participating in this insightful discussion. There is certainly a lot of work ahead for most businesses in the coming weeks, and then beyond that in terms of managing ongoing compliance with the requirements of POPI. And there still are many questions that remain unanswered, and I'm hopeful that with the cooperative, inclusive attitude adopted by the regulator, that we will all collaboratively get through this together. And we at Cliff Decker understand our clients' needs for effective solutions to data protection compliance, and with this in mind, we've developed tailored compliance toolkits to assist you in your compliance journey. Thank you very much for attending, and we look forward to meeting you on future webinars like these. Thank you.
Our clients are the types of clients who typically don't only have a national footprint. Invariably, those clients have footprints in other parts of Africa. And so we set about sort of trying to find the right partners to use our collective sense of our respective markets for the benefit of our clients, firstly, and for the benefit of our firms.
Kieti is joining forces with Cliff Decker Hofmeyr because Kieti has enjoyed steady, consistent, and exciting growth over the last 4 years. Together, we'll be able to offer our clients the best service possible, and we will be a true partner for our clients' businesses.
As is typical of our firm, we want to do things differently. We want to form a real partnership with our colleagues in Kenya, and the way in which we're trying to do it is absolutely peppered by designing everything that we're going to do and designing it together. What we want to do is to actually improve what we both offer collaboratively and to actually learn from each other.
What makes us gel with Cliff Decker Hofmeyr is the similarity in our culture. We find them to be incredibly nice people. They are very kind, and we think they will be, to us and to our clients, a true partner. So we're incredibly excited that this combination, we see it enabling us to become a powerhouse in the Kenyan market. And together with Cliff Decker Hoffmeyer, we'll be able to grow into the wider African market as a true Pan-African law firm.
For us to be taking a move that is a move into wider Africa, from a professional services perspective, this is a very small piece of quite a significant movement that is meant to be happening and is going to be happening on our continent. So we are very excited about what this holds from the perspective of corporate legal services on the African continent.